Good afternoon, everyone. Welcome. Thank you for joining with us today. Let me make sure the captions are over where you guys can see them. So thank you for joining today. We will be having a training regarding working while on Social Security benefits. I'm Maya Manis. I'm the staff attorney here at Benefits Law Center, and I'm with my colleague, directing attorney for our disabled homeless advocacy program, Hillary Lovell. And we will get started as people trickle in. To set context of the purpose of this training, in 2020, more than 30% of Washington households were receiving Social Security benefits, which provides critical cash due to having a disability or retiring. Unfortunately, due to rising costs in housing and food prices, many are still needing to work to maintain their stability. While one can work while on Social Security benefits, as you will find out today, there are complicated rules that us advocates can know to help support a beneficiary to maintain their benefits and therefore stability. We are doing this presentation in line with our Give Big campaign to support this work that we will be sharing with you today. Throughout this presentation, there will be opportunity to donate, and I'll put in the chat right now our Give Big campaign. Our agenda today is very dense, but we hope that with all that we cover, you will at least remember one thing that can help a friend, family member, or client keep their benefits. We will go over generally what the benefit programs are, the different work rules, and the possible problems one may face while they're working. Throughout the presentation, please feel free to ask questions. The chat is enabled. There is also a Q&A function. We will try to respond to the questions directly in the chat throughout the presentation. If we need to answer it live, we will do that as well. But there will definitely be time at the end to be able to answer questions. As the work rules are very fact specific, we do ask that you keep specific questions about someone's benefits out of the public chat to maintain privacy and confidentiality. At the end and throughout the chat, we will have our contact information that you can reach out directly so we can respond to those specific questions. With that, I will pass it on to Hillary.
Thank you, Maya. We're just going to do a brief overview of some of the programs so that we have similar context and language to get us all on the same page as we get to the specific rules. Some of the rules apply just to disability insurance. Some are applying to SSI. Just as a quick refresher, Supplemental Security Income, SSI, is a needs-based program. It has income and resource limits to be eligible for that program. Disability insurance, on the other hand, is related to somebody's work history. You must have earned work credits that have not expired to still be eligible for that program. It is essentially your retirement fund, your retirement, Social Security retirement that you can access early. Even beyond early retirement age, you will be eligible potentially for your full retirement amount if you are insured under that program. And to look more specifically into the programs, the next slide goes into some program details. You know, some of this is not necessarily related to work rules, but just keep these in mind. SSI, you can be 65 or older to be on SSI, blind, and you meet the definition of disabled. The same definition of disabled applies to both programs. So if you have a client on either of these, they still must pass the disability analysis, which we'll go over in a moment. And the benefit rates are different. So the SSI FBR federal benefit rate in 2025 is $967. When we're calculating later, work earned income reductions on SSI, FBR federal benefit rate is part of that calculation. So just keep that in mind. Whereas with disability insurance, the client's income benefit amount is based off of their individual work history. Again, this is what their full retirement amount would be if they reached full retirement age. And you earn work credits every year, up to 1 credit per quarter if you've earned that work credit dollar amount. For whatever reason, Social Security has designated different dollar amounts for different things. So we'll be highlighting a few of those in this presentation, but the work credit dollar amount this year is $1,810. So if you've earned that in 1 quarter, it's pretty easy to get to that. You've had a work credit, but they do expire over time. Your your retirement amount is still there, but to be eligible for SSDI, you must have work credits that have not yet expired. So what is disability under, quote unquote, under Social Security's definition? For this presentation, we really just are focusing on the first step, really, which is substantial gainful activity. That is the dollar amount that Social Security sets every year that is a baseline. It is a fine line. If you're above SGA, if you've earned substantial gainful activity above the 2025 dollar amount of $1,620 or more for an individual, it is $2,700 if the individual is blind. If they're non-blind, it's $1,620. If you've earned above that, you do not pass the definition of disability past step 1. There are some exceptions, which we'll go over, but generally speaking, that's the first thing that Social Security will look at when they're evaluating whether a claimant who's applying for SSI and or SSDI is disabled. Then they go on to, your medical history, your severity of your conditions, and functionality. But the very first thing they look at is SGA. And this is a sequential evaluation process. So they start at 1. If you are earning SGA, you're not disabled in the way that Social Security defines it. And going a little deeper into that, so there are some exceptions, which we'll get to. SGA, substantial gainful activity, is defined in the regulations, and I've cited here just to the SSI regulation. 20 CFR 404 starts with is Title II for the DI regulations, but it's similar. So substantial is defined, it means significant physical and or mental activities. So the work that somebody is doing has to be that. So there are some, maybe you can make some arguments that it's not substantial for some reason. And it also has to be gainful, that the claimant or beneficiary has performed work for pay or profit, or intended for pay or profit, even if they're not receiving that pay or profit. So you have to ask some questions. It's a possibility you could argue for your client that they might be earning some money. It is earned income, but it's actually not gainful. You can make some arguments there. In a little bit, Maya will go over some of those exceptions, like was the work subsidized? Was it a sheltered work environment or a special condition, perhaps? One easy example, if you've ever had a client that was client of DDA, maybe they had intellectual disabilities and they were in a specific sheltered work program or workshop, they did earn income, but it was more for their benefit of being integrated into a community setting versus performing work and being paid for the output of their work. And Also, SGA is gross. So this is not net. It is gross earned income. I know a lot of my clients get tripped up on that because they just see their pay stub and they think this is how much I've earned, but it is the gross dollar amount, not what was deposited. And uh, I think a lot of people do get tripped up in this section when they are already on benefits and, they suddenly have an extra shift that they take. They're not taking into account that might bump them up over SGA. One other way to get around SGA, even in applications, I've argued this, maybe later on, you can say if it might be an unsuccessful work attempt in situations where somebody has worked SGA for a short period of time, 6 months or less. You might argue that that was an unsuccessful work attempt. They attempted to work for this period of time, and they could not sustain it. So that might also prevent, at step one, when somebody is applying, it might prevent them from not being eligible. You could argue, well, they did have some SGA work, but it was an unsuccessful work attempt. They weren't able to. It really should be because their impairments prevented them from being able to work, or maybe some conditions were removed that enabled them to work. Even with extensive supports or accommodations, they couldn't maintain that level of work or the number of hours that would get them above SGA threshold. There's some arguments that you can make there to get around the situations where somebody had a short period of SGA.
Now that we understand substantial gainful activity, I will now go over some of the exceptions that could lower the amount of wages to have it fall below the allowable amount, that substantial gainful activity amount, or indicate that their wages were never substantial and therefore cannot be substantial gainful activity. These exceptions are wonky, and they make sense on a legal sense, but when you try to talk to employers about it or even beneficiaries about it, it doesn't make sense in a practical sense. So please, if it doesn't make sense or whatnot, please ask questions and I'll try to clarify. The first is sort of exception that Social Security will look at is if there are subsidies or if their wages can be subsidized. And with a subsidy, it is indicating that the employer is paying more than their reasonable value. That is how it is indicated in the CFRs. On a practical sense, it's basically stating that due to the person's impairments or limitations, they are not fully performing the job similar to their coworkers or what is within their job description. And so because of that, they're not meeting all of the things needed within the job description. The employer is therefore paying more for their work, and therefore it can be subsidized by the employer. It is subsidized by the employer. How this works is Social Security will ask how much by a percentage that their wages are being subsidized. So if the person is only doing a little bit of the job description and can't do majority of it, the subsidy percentage would be greater. If there are some things that they can't do, but majority of the description they can, then the percentage would be decreased. It can be as little as 10% for a subsidy, and I have seen it as much as 50 to 60% for a subsidy. And with that percentage, Social Security will then use that percentage with their wages to lower the actual countable wages that Social Security will use to determine if they are above or below substantial gainful activity. This can be something that can happen preventatively, but this typically happens after Social Security has found that they are above substantial gainful activity. And this is used to see if they can resolve an outstanding overpayment or any other issues now that they're above substantial gainful activity. We'll go a little bit more over subsidies, but this starts out by a work activity questionnaire for the employer to complete to see sort of what are the particular assistance or supervision or anything that's unusual for this person that they are doing. And then we'll ask the employer to indicate a percentage. There is also a way to do a non-specific subsidy where they don't need to contact the employer, or if it's been an unsuccessful contact with the employer never completed the questionnaire. And Social Security can then create their own subsidy percentage by understanding the skills and responsibilities of the job, as well as the assistance provided by the employer's job coaches, or different limitations that the claimant may have. Now, moving on to special conditions. This one is extremely fact specific, depending on how the job is set up for this specific person is really an indication on if special conditions can apply. With substantial gainful activity, typically Social Security makes a determination on the gainful part alone. If you make above a certain amount, you're automatically above substantial gainful activity. But as Hillary mentioned, it's technically a two-prong analysis. And the work activity must be substantial and it must be gainful. So with the special conditions argument, you are essentially analyzing the substantial aspect of the work activity and if they are contributing substantially to the business or able to do ordinary or simple tasks at a satisfactory rate. There are many factors, and we'll go into that in the next slide in terms of what could qualify for special conditions. A really great indication is if they're in a government-sponsored program, they have a job coach that assists with their supervisor and the person themselves. So under special conditions, it is stating that the work activity is not substantial and therefore cannot meet substantial gainful activity while they are at the job where they're specifically located. And then finally, we have sheltered work environment. This is similar to the government-sponsored program, but it is a specific location for people with disabilities, and it is designed to assist people with disabilities to maintain some work or integration within community. So like I said, this is a list of some facts that could point into the fact that there's a subsidy or special conditions. If they have tasks that are specifically tailored for their special needs, that could rise to the level of having a job under special conditions. As well as having a job coach is also really helpful. What I have seen is Social Security will try and work up a subsidy to see if they can subsidize their wages before looking into special conditions, because special conditions is a really high bar, and stating that someone is under special conditions is stating that they can never meet substantial gainful activity. And so that is a higher threshold that the local field offices may not look for. They'll try to look and see if a subsidy can qualify. Special conditions can be a really good argument, though, for an appeal of an overpayment or disability cessation issues, especially if it's appealed to a hearing level. So looking at subsidies in practice, as I indicated earlier, the first step is to complete a work activity questionnaire. They made the language a little bit clearer that hopefully employers will be able to understand. What I have seen in practice is that the employer just won't fill it out because they don't want to make an indication that they're subsidizing their wages. But now with the new form, it should be clearer, as well as it doesn't necessarily only have to be the employer now. A job coach can also complete the work activity questionnaire if they understand the job and assist the claimant with their job active or their work activity. And then typically for subsidies, there needs to be, they'll look at a subsidy if there's a childhood disability or a mental impairment or government sponsored program to sort of flag that they could look into a subsidy. But just once you try to go through the process of subsidizing someone's wages, it could be really helpful to resolve an overpayment or get them back on benefits, but it may cause continual issues to ensure that the subsidy and special conditions are applied. There are many different processing centers, field offices that are analyzing somebody's work activity and wages that they may not be talking to one another. So they could have a subsidy or have special conditions applied, but later down the line, still receive an overpayment or post-eligibility issue just because off of their wages alone, it could look like they are working above SGA or substantial gainful activity. So this is a really useful tool if somebody has an overpayment or their disability has been ceased, but just know that it could open the door to have continual engagement with their local field offices or receiving a post-eligibility notice from Social Security. The last exception or way in which you can reduce somebody's wages that is above substantial gainful activity is by impairment-related work expenses. This is related to the severity of their impairment. This must be paid by the person, and there is no chance for them to be reimbursed by the cost. Some examples used is, and if there's a specialized transportation that they need to be able to get to and from work, if they need specialized orthopedics to be able to work, or specialized alarm clock if they're hard of hearing, are some examples. There's probably a list, way longer list than that in terms of what could be impairment related work expenses. So this could be something to ask the client. If Social Security states that the person is working over substantial gainful activity, the expenses would need to be spent in the month that they are above substantial gainful activity. But this could be a tool used to help reduce their wages and can reduce the amount of an overpayment or the opportunity, or give some of their trial work period back, which we'll go over a little bit later. So those are some of the exceptions in terms of they are now above substantial gainful activity, but some ways to reduce their wages to get them below substantial activity. And I think now I'm going to pass it on to Hillary to talk a little bit more about the different work incentives while on benefits.
Thanks, Maya. And it is funny how Social Security frames these as work incentives because, as you'll see, in some ways it disincentivizes individuals to work. So SSI, if somebody is working while on SSI, that is considered earned income. And Maya, if you can hit next, I don't know why I put transitions on this one. But working while you are on SSI, will result, they call it an incentive because they're only going to reduce your earned income um, by $1 for every $2 earned. Compared with unearned income, they reduce it dollar for dollar. So for example, mom gives their disabled adult child money directly for rent. That's a big no-no. That's going to be, then every dollar that parent gives to the child, their SSI is going to be reduced. However, if that child gets a part-time job and earns a little bit of income, they're only going to reduce their SSI by 50%, $1 for every $2 earned up to SGA. There is a general exclusion, $20 for any income, whether it is earned or unearned. And there's also a $65 earned income exclusion that applies to all of your income that you've earned that month. So, be aware what the SGA amount is. So, you have that incentive, quote unquote, incentive to work. A beneficiary does have an incentive. They can work some. And there are some cases, and we're going to go over a sample calculation in a moment, where you might actually have more take-home pay by having some work and SSI, even though your SSI is reduced. However, SGA is a threshold. And if you earn above that, you, as a SSI beneficiary, that person would receive no benefit for the month they earned SGA or more. Just like there's a threshold for the resource limit, the $2,000 resource limit, if your client has $2,001 in their account the next month, that client gets $0 of SSI because they're above resource. So similarly, income is a threshold, that SGA is a threshold. Like I said earlier, this kind of trips people up where they have seasonal work or inconsistent work, where their hours are going up and down and they're having trouble tracking what their income is. And we've also had clients where their employers give them a raise, which is really nice, to be rewarded for your work. And but we have seen clients where, they're just working at just barely that threshold where they may no longer be able to get their SSI. And that can create problems going forward with a potential CDR issue, a continuing disability review. Maya will talk about that towards the end when we talk about some of the pitfalls that we see here. But, working some income at any rate, especially on SSI, and you're earning some income and they're reducing your SSI, your benefit rate that you're getting each month, they might start to see, hey, this person is regularly earning SGA. That could actually trigger the agency to do a review of this person's disability. And CDR will look at whether they've medically improved to the point that they're not disabled, quote unquote, disabled under Social Security's definitions. For some people, that might actually be a better outcome. Maybe they can work SGA and sustain that, and that actually is a better outcome for them because they can continue to work and earn as much as they want, and then they're still paying money into the retirement system. And maybe if they become disabled later, that's a disability insurance claim potentially. But as we know, Social Security applications are not easily approved and are not processed quickly. So that's one thing here. And the other thing to flag, which we're going to keep flagging, is beneficiaries must be reporting this. If they're, as we're going over this calculation, you see they're calculating it every month. And so that means they need to be reporting every month, because that again could cause some problems with their benefit. And especially if they started a new job, Social Security won't know that employer until maybe the tax season rolls around and the employer reports on their taxes. I have had cases where I've called in to Social Security on a client's issue with income and wages, and they may see quarterly reports. It sounds like the field offices have some access through the state to see some quarterly income, but I don't know how frequently they do that. I just know that they catch it late and then it can become an overpayment. So moving on to SSI, earned income, how do we actually calculate this? You start off looking at your countable unearned income, which again, you can subtract $20, then look at your countable earned income. Again, you're taking out 65 and divide by 2. And then we add those together to get the total countable income, which we're going to subtract from the federal benefit rate. And that will tell us how much our SSI payment is. That could mean that their total income is actually more when they look at their SSI payment plus their earned and unearned income. So to look at an example of how this would work, so let's do the first click, Maya, and stop here. So the dual beneficiary Sam, let's just say he earns $550 $1 in gross wages, again, gross, not net wages, and $337 of SSDI. So there are clients that are dual beneficiaries that get both benefit amounts because his disability insurance, you can see, is only $337. I've definitely had clients that had enough work credits, but maybe their work had been pretty sparse or they didn't earn enough to have a lot of income. It could be also a situation, especially where there's a client who's younger than 31, so they needed less work credits to qualify for disability insurance. I have seen that happen, so their benefit amount was lower, and they could be on both benefits. In that case, DI, disability insurance, is counted as unearned income. And so the general income exclusion is subtracted from that. If there had not been disability insurance, you could subtract both the general income exclusion and the earned income exclusion from the earned income. So here he has $317 of countable unearned income after you subtract the 20. For earned income, we take the $65 earned income exclusion and then we divide by 2. So he's $243 of earned income and total countable income is $560. So if you click one more, Maya, it'll show that the federal benefit rate, when you subtract the total countable income, he still has $407 on SSI. And when you add that together with his actual wages that he earned, the $551, and the disability insurance that he's already being paid, his take-home pay is $1,295, which if he was only getting SSI and decided not to work, he'd be getting $987 actually, because if you get SSI and SSDI, they take they give you that extra the $20. So he's getting more take-home pay, and that can actually be a good thing for folks to consider. This is where I tell folks, if you're gonna work, take it slow and see if you can actually do it, and you're still gonna get your SSI. So that is related to SSI, but what about folks that are working while they're on disability insurance? That is a different analysis. They are not reducing your income at all. They don't have a 2-for-1 reduction. The incentive, quote unquote, for disability insurance beneficiaries is that you can work for a period of time, which Social Security calls the trial work period, without any consequences to your monthly benefit amount. However, it's not this test to whether you are working during that period. They have a dollar amount, which is yet again different from substantial gainful activity. This is the trial work period amount. It is a trigger that will count the 9 non-consecutive months during that trial work period. So you'll notice in 2025, it's only $1,160 gross each month that would count towards the trial work period. This period, so you can earn 9 months. They do not have to be in a row. They can be non-consecutive, and it's a rolling 60-month basis. So for 5 years, they're going to look at, especially for people that have very sparse income, it may go up and it may go down. If you don't have any months where your trial work period has gone above that trigger dollar amount, or if you've not had 9, the 60-month period keeps rolling forward in time with you. And they'll count up to 9 months at that point. We're going to do an example in a moment so that you can kind of see this on a timeline in a visual sense that should help. After that 9th month, during that trial work period, where client has earned the trial work period dollar amount. Then the trial work period ends and the client is now in the extended period of eligibility. When you're in the extended period of eligibility, the next month that you've earned SGA, your benefits cease. So while you're in the trial work period, I think where a lot of people get tripped up here is maybe they're not reporting or they are reporting. They actually don't know what their trial work period amount. They often don't know when it starts or ends. They don't even know they're in a trial work period. So make sure that the client is keeping track of their work, keeping track of their gross wages, advise people to do so. And if they're not sure, they can contact Social Security and they should be telling them. And also theoretically, if they're able to set up a My Social Security account, they might be able to get some information there. And then to talk a little bit about the EPE, extended period of eligibility. So this is after the trial work period ends, and this is a specific time period. It's not rolling like the trial work period. This is 36 months, and it's your re-entitlement period. So it's kind of a period of time where, again, you're kind of the client, the beneficiary is testing their ability to work. They're going above, and now we're in SGA world. They don't care about the trial work period dollar amount anymore because the trial work period is over. We are back to substantial gainful activity. So you're going up and down. You may have no earnings during this time. If you have any earned income during this time as a disability insurance beneficiary and you're in your EPE, any month that you earn SGA or more, your benefits are ceased or are in cessation. That is a pause on benefits. The next month, if you earn below SGA, your benefits can restart. And remember, this is supposed to be anytime somebody is working, that beneficiary is supposed to be reporting every month their income by the 10th of the next month. So the important thing will be to keep reporting and keep a track of how much you're earning. And for clients that want to stay on disability insurance, it's really important that they remember to look at their income, keep track of their pay, their gross pay, and just be aware of that. The second, after that 36-month period ends, if they earn above SGA at all, they are terminated. Their benefits are terminated and they must reapply to get additional benefits or expedited reinstatement. But there's a 3-month grace period where the individual will still get their same monthly benefit amount, even if they've reached termination during the extended period of eligibility. There'll be 3 additional months of benefits that they will be entitled to. So to give the trial work period and EP into a visual perspective, we have a little example here for you. Just to start here, you see that, again, remember that the trial work period amount is 1160 this year, SGA is 1620. We're looking at saying this is 2025, but of course it gets complicated because over time there's cost of living adjustments. So what I didn't do to overcomplicate this is every year we're actually looking in time. There's a different trial work period dollar amount and a different substantial gainful period amount, SGA amount. So there could be a case where you have a case and this is the 60-month rolling period is over 5 years and you have to calculate the wages based off of the trial work period and dollar amount and the SGA amount for that year that it is earned. But we're just doing this example simply. I'm showing here somebody has started to work. They're on disability insurance and they're any month where they've earned 1160 or more, we're starting to count their trial work period. And here we have 8 months so far where they've earned. Can you do one click, Maya? Now we see when a second they hit the 9th month where they have earned SGA, and we're going to assume this is within the 60 months, the trial work period ends. And that is a specific date. Now we know the time frame here, and we know the time frame on when the extended period of eligibility ends. So now anytime this individual works, now they're focused on whether they're earning SGA or not. And now, one more, Maya, sorry. So we're seeing, okay, they earned below SGA, no problem. But the second they earn above SGA, now we're in cessation or pause. and their benefit is paused. But the next calendar month, or whenever they are worked again, they went below SGA, they can get their monthly benefit amount. So that happens during that time period. Now what happens after the EP ends is any month and you can do one more. Yeah. And there's actually one more after this. You might as well just hit it. Any month after the EP ends, if they earned SGA for that calendar year where it is earned, they're terminated. Also in this whole period of time during the EPE, this is where we often see overpayments. This is a big red flag because, again, people are not always aware. Beneficiaries are not always aware when their trial work period has started or ended. And all of a sudden they're in the EPE that they weren't aware they were in, and they're just working and earning because for the first 9 months, they received zero consequences to their benefit amount. And they weren't aware that there was this trial work period. Now, all of a sudden, they have earned above SGA. And probably by this time, Social Security has gotten some information either from the IRS or from state agencies informing them about work, or maybe the client has reported work and Social Security just finally got around to reviewing the paperwork and assigning this to somebody who's done the work. And they're like, whoa, we've paid you too much. You actually should have gotten zero income for, however many months. And then that generates an overpayment. So I know these rules are kind of confusing. I have to kind of do a visual representation. And then I have a couple more points before moving on. Next slide though. This trial work period analysis, oh, one more, sorry, go back. Yes, the trial work period analysis can be evaluated. Generally, it's, of course, for people who are already on benefits, already on disability insurance, they have a trial work period. But the question becomes, for those of us who do eligibility cases, we are waiting for somebody to get approved. It could be a number of years based off of appeal process. Do we have the benefit of this trial work period analysis for a claimant who is not yet, for a disability insurance claimant who has not yet been approved? And the answer, thankfully, in our circuit is yes. In the Ninth Circuit, you can argue. And the ALJ should be applying the trial work period to pending claims. The case law that we have for this, which Jordan Goddard, the federal attorney in our area who gives us so much information, he taught me this, and I successfully used this in a case. Lingenfelter v. Astru is the case that you can cite for this. That case is mostly focused on claimant credibility and how ALJs are supposed to handle claimant credibility. And in that case, the claimant, the ALJ took information and testimony about the claimant having a short period of work during the appeal process to attack his credibility about the severity of his claims. But in that analysis, the Court of Appeals said, actually, the trial work period guidelines are significant when you're evaluating this pending claim. Because when you're in the trial work period analysis and the regulations themselves, they are, the administration is not considering whether the person is disabled or not. It is, there's no consequences, remember, for that trial work period. And it's not triggering a disability review. This is an incentive to get people to work. So you are not required to prove whether you're disabled or not. So, by correlation, the court essentially, and this, we can use this for the argument that the court should be applying the trial work period analysis to pending claims. And it can extend to, if they have a grace period afterwards. Unfortunately, the case law doesn't extend further and talk about an extended period of disability. That's kind of a gray area. And the case law that we have, as I understand, does not go far enough, because this case was really more about claimant credibility. And we don't have case law on the books right now that address specifically that issue that I'm aware of whether the EPE, the claimant who hasn't been approved yet still has the benefit of the EPE time period there. The courts really are only required to look at the trial work period plus the 3-month grace period. So to give you an example from the case that I used, the next slide, what I really did was I created a spreadsheet in Excel, and this is not that. This is a table I made for my brief to illustrate the point to the judge specifically about what months we're counting and what months I'm arguing for my claimant to get the benefit. But I had to create an Excel spreadsheet and get all of the pay stubs and enter all of that and calculate totals for each month to figure out, was this person above trial work period month? And you also have to do it by year. You see this is going from the years 2014 to 2020. So there were different trial work period dollar amounts, different SGA amounts for each of those years. And this also illustrates that, counting the 9 months, between 2014 and 2018, they were actually the first 3 months where the client had SGA, they were outside of that rolling 60-month period because they didn't earn 9 months within 60 months. So then we just moved the time period forward more. And then we got 9 months of SGA. This is a period when the claimant had quite a bit of work and they did go through the 9 months consecutively, and then we got 3 months of grace period. So this ultimately ended up being treated like a closed period of disability, but the claimant got a big chunk of back pay. So I would encourage you, if you still have a pending claim and it's at a disability insurance claim and you're at hearing, argue the trial work period. If you're not already doing that, or take a look at the wages, spend some time looking at the wages, looking at the actual earned income, and you can develop that argument that, especially in cases where we've had closed period of disability argument, adding the trial work period argument to it will give you a longer period of disability and hopefully a larger installment of underpayment or back pay for the claimant at the end of the day.
Thank you, Hillary. There was a question in the chat regarding how many trial work periods a person can have each year or once in a lifetime. And so I want to explain that a little bit more than I did in the chat. So you do get 9 months where you can work as much as you want, but it can't be more than 1,100. If it's more than 1,100, then you exhaust your trial work period that month. Technically, if you, let's say you worked above substantial gainful activity 1 month, then 60 months happens, then that trial work period month would technically fall off. But it is a 5-year period. So it tends to happen where somebody within that 9-month period will exhaust their trial work period. And moving on to expedited reinstatement, if they are successfully able to do expedited reinstatement, they will then technically get their trial work period back. So there is an opportunity to extend your trial work period if it's been longer than 60 months, or if you do the expedited reinstatement and get your benefits back on. But after a person exhausts their trial work period and their extended period of eligibility, when they work above substantial gainful activity in 1 month, they will be found no longer disabled and therefore not able to receive benefits. Like Hillary says, if a claimant is not reporting their wages timely, as well as just the bureaucracy within Social Security, the cessation of benefits or being able to be found no longer disabled tends to come with an overpayment. So it is most likely where some months have gone by when they continued paying you even though they should not have. And so the claimant will receive a letter saying that they are found no longer disabled and therefore no longer able to receive benefits. And then with that, we'll receive another letter that indicates an overpayment for the months that they should not have been paid because it was the time after they worked above substantial gainful activity. And so with that, the claimant has two options, right? They can continue working above substantial gainful activity, can be really helpful. They're adding to their benefit amount and their retirement record, or they're paying FICA taxes. So it can be beneficial to continue working if they're able to. But if they are no longer able to work due to their disability, and their income has decreased, that it is now below substantial gainful activity, they can go through expedited reinstatement. They have a 5-year period to do expedited reinstatement after they worked above substantial gainful activity. And so this review is supposedly expedites the disability review, and also allows them to receive 6 months of benefits. So they will receive benefits for 6 months while this process is happening. What I have seen with expedited reinstatements, it's a similar timeline with eligibility cases. It can take upwards to a year, but those 6 months of provisional benefits can be very beneficial for somebody, as well as if there hasn't been a decision on their expedited reinstatement and their provisional benefits have ceased, there is an opportunity to maybe ask for a critical payment. So the expedited reinstatement starts when a claimant engages within Social Security to state that they would like to get their benefits back and they would like to do an expedited reinstatement. And during that conversation with Social Security, they will be able to look to see if it's best to reapply to get a higher benefit amount or go through the expedited reinstatement process. And the expedited reinstatement process happens after they worked above substantial gainful activity after their extended period of eligibility, and they worked above SGA. So if they get a letter in the mail saying that their benefits have been ceased, and they need the benefit right away, it may be best to do the expedited reinstatement. If it's something that they can work and they've worked for a really long time and it's been, within that 3 to 4 or 5 year mark since they have had their benefits ceased, it could be a conversation to see if it's best to reapply and do the application from the very beginning, as it may increase the benefit amount since they've been working and paying into their record. But meeting with Social Security would be the best way to help that claimant decide what the better option would be. Now, I'm going to just do the caution and the risks and the problems that could fall while working on benefits. Hillary talked a lot about, on SSI and the income amount that would qualify, and then also talked about with SSDI, the timeline associated with it. But the big takeaway is, while working on benefits, the claimant is always going to run a risk of collecting an overpayment due to working, especially if they're close to substantial gainful activity, and especially in King County or Washington State, since our minimum wage is so high, it is even more likely for somebody to work above substantial gainful activity because it doesn't take a lot of hours for them to be able to get there. And the exceptions earlier can help resolve that overpayment by asking Social Security to subsidize their wages, so their income is now below substantial gainful activity, or say that they're in under special conditions or special sheltered work environment. There's also the option to request a waiver. That's not something we'll be discussing today, but is also an option. So there is always a risk to have an overpayment. And so it's always best to report timely. And then if somebody has received an overpayment, look to see about those exceptions that we stated earlier. There are also periodic reviews to see if the disability is continuing. This happens randomly, and we'll go a little bit more into this in the next slide, but working can trigger a continuing disability review. And finally, while working, benefits can be ceased and therefore terminated. So within a year on SSI, if you can indicate that your income is now below the required amount, you can get your benefits back on. And then with Social Security disability insurance, like we said, it has a lot to do with their trial work period and extended period of eligibility, but your record is terminated and you will need to reapply 5 years after that extended period of eligibility. Moving on to talking about continuing disability reviews. This Social Security must evaluate a person's disability from time to time. That is how it states within the federal regulations, and to see if they're still eligible for benefits. There can be multiple reasons for somebody to have a continuing disability review, but one of them can be the failure to follow the Social Security rules. So working above substantial gainful activity is technically not following Social Security rules. The review process is very similar to an eligibility analysis, but they're really looking to see if there's been medical improvement. So they're seeing, has there been any improvement regarding the severity and if they're still meeting a listing. And with that, there is a residual functional capacity analysis that is the same with an eligibility case. And that is to see if somebody can do any past relevant work or any work within the national economy. So if somebody is working substantially and then have a continuing disability review, it could cause there to be an unfavorable outcome because there's evidence that they are and can continually work, specifically their past relevant work as they are currently working. So it can be very difficult if somebody has been working and then can get a continuing disability review to get a positive outcome because of that analysis of employment and work. So we're close to the end and be able to do some questions, but before we get into that, I wanted to just provide some practical tips on what to do if you know somebody who is on Social Security benefits and are working. It is best to report wages every month, and it's best to do that with your pay stubs. There is an online portal with both SSI and SSDI to report your wages. You can also do it over the phone for SSI, which is the number on the screen. So if there's been any changes in employment, so if you get a new employer, report that. If you are working, report it every month. For Social Security disability insurance, Social Security may tell you that you don't need to do it every month, but it is best to do so. And it's also best to prevent um, a continuing disability review or a potential overpayment is just to advise clients to stay below that substantial gainful activity limit. It changes every year. So we usually get the new amount late fall, early winter, so October to November, December time. And so keep an eye out for that. So a claimant may know how much they can work and let them know that it's gross wages per month. This can be very difficult for people when their pay stubs overlap and extend over into the next month. But just to keep in mind to try to stay below that amount. And then continuing some advice on considering working while on Social Security benefits. If they are able to do work above substantial gainful activity, it may be best to get off benefits and work as they are adding to their record. And there's no strings attached if they're working in comparison to if they're on Social Security benefits. The con to that is right now it's taking 12 months to once you apply for benefits for you to get an initial decision. So it can be really difficult for somebody to get on benefits in the first place. So that is something to think about when thinking about going back into work and if you are able to maintain it. If you're working and on benefits, you will always need to be reporting, and there's always that risk for potential overpayment. And it will always sort of fluctuate depending on if your hours are fluctuating and your wages are fluctuating. And so with that, we have some resources. We are going to be sending out this slide to folks shortly after this presentation, so you'll have access to this. But the SSA Red Book is really good to understand a little bit more about what we're saying about the different trial work periods, different work incentives, etc. The work activity questionnaire. Just this is helpful to review, to know a little bit more about what they're looking for a subsidy and or special conditions. We didn't talk about it, but there is also the PASS plan, which is a way for somebody who is on SSI to save more than the $2,000 resource limit, but it has to be related to work, starting a business, or school. So that could be something to look into if somebody is wanting to go back to school or starting a business, but are on SSI. And last, but not least, we can help with the Social Security side of employment issues, but Disability Rights Washington can be really helpful if somebody is experiencing barriers to employment and needing assistance with navigating employment issues. So with that, I believe we are at question time. And so I think.
Yeah, Maya, we have some questions in chat. So I'm going to ask you a couple off the bat that relate to what you were just talking about. Do employers / the employee have to submit the subsidy form every year?
I do know that they need to submit it. They may be asked to reevaluate the subsidy amount. It probably depends on the local field office and when they have any outstanding issues with that claimant, if they're above substantial gainful activity or if they've been a new employer. Like I stated earlier, with completing that work activity questionnaire, it can be really helpful to resolve the initial issue that the person may have, but they may need to update it if the processing center, for instance, believe that they're working above substantial gainful activity, and so the field office may request a new questionnaire if they're doing reconsideration request on it. So I would say it truly depends. It could happen where they to get need to fill out that form again.
Mhm. And what about pay stubs? So someone's
Mhm.
asking, what do you do with clients who can't get their pay stubs recorded at the local office? I'm assuming that means, they can't get the local office to actually process the pay stubs that are submitted. Um, what are the best ways to get a recipient's pay updated within Social Security so their monthly benefit is correct?
Yes, I'm assuming this is maybe an issue because right now field offices are going appointment only right now. There is a drop box at local field offices. My advice is if you put something in the drop box to get try to get it stamped by somebody from Social Security, or at the very least get a ticket from their kiosk at the very beginning indicating that you're dropping off forms, so you have a timestamp in terms of when you drop it off, because with the drop box at the local field offices, it can sort of go into the abyss in terms of did they receive it, did they not. You can also fax to your local field office or mail them. You can also do the online portal that we indicated earlier in the slides. Um, Hillary, I don't know if you have any other
The only other thing I would
suggestions.
add to that, I know I've had clients come to me just like on advice and counsel where they've already submitted it and Social Security says they never got it by mail. So, I know it's an extra cost, but getting return receipt, getting proof that you've submitted it will help later on when you get to, overpayment scenarios, because you can show I'm not at fault. I literally did report this to you and you didn't process it. But I think this is always going to be a barrier. We have heard that they are, and of course, who knows if it's going to happen now, but they were working towards an automated reporting system from employers when they're reporting wages for tax purposes, that it would also be reported for Social Security purposes. That is yet to be seen, but we know technology is supposed to be working toward that goal, starting with the DI recipients, for whatever reason, not everybody, but hopefully that will alleviate, because Lucinda, you're right. It's not easy. And I've had plenty of clients that have reported and it actually hasn't been recorded properly or timely, even though the client did report timely. Um, Another question we have here related to subsidy, so if for SSDI clients who are being paid by DSHS to be a paid caregiver of a disabled family member, we've definitely seen that scenario in our office. So if they're being paid above SGA, are they not, or can we successfully argue that they're not engaged in substantial employment? And I know that issue has come up. Um, I mean, it depends on the scenario. Again, these are all case by case scenarios, but especially for an individual who the only reason they have that employment is because of the special relationship with the disabled family member that they're the caregiver for. They wouldn't be able to do this, especially if their limitations show they wouldn't be able to do this work as a caregiver for anybody. Like they wouldn't be hired as, a health aide to uh, work with a temp agency or work with a caregiving agency to be placed in any home. The only reason they are hired is because of the special relationship they have, and also showing that, presumably there may be other family members who are also doing some of the caregiving in the household. And what is the analysis will turn on what does that SSDI beneficiary actually do? And what is that work? Is it actually substantial? You're right, is the question. And We have ongoing cases where we're arguing back and forth. It is an argument that you have to really push the agency for, because especially at field office level, they're gonna just see the dollar amount and say no, boom, rubber stamp it. But this is a good place to make that argument that it's not actually substantial. And so the question is actually, is it a is it a subsidy where there's a different amount, or is this actually a special condition where none of the income should be counted? That's a hard argument to make. Like Maya said earlier, the agency doesn't like to do that. But when you're looking at that analysis, this is a special condition. They're not getting hired by anybody else to do that job. They're not going to go on the open market and do that job. So reality, I think if we're looking at the rules, I think that's probably the argument. But what's more likely to get approved is, frankly, a subsidy. And then another question I see here, Maya, and feel free to add to that one too, is does Social Security money based off of disabled adult child benefit, when the parents start taking their Social Security, is it considered to be SSI income? Um, so none of that is going to be considered earned income for wage purposes. If somebody was on SSI, for example, and then their parent retires and now all of a sudden they're eligible for disabled adult child benefits, or for whatever reason they can be on disabled adult child benefits, that is the benefit that they'll be on. If it's above SSI, they're not going to be on SSI anymore. Hopefully that means that they will transfer to the correct program and they'll get DIC benefits. And hopefully that benefit amount is much higher than SSI and they have a higher benefit amount. Let's see here.
Yes, and just to add to that, if somebody is on DAC benefits and then they start working, it can get really complicated in terms of when their benefits for their DAC will cease, and then because they're going to start collecting on their own record. So it is with specifically DAC benefits, there is sort of a special caveat to what we were saying, with in terms of what they're able to do in terms of working, because they may get their benefits ceased because they can now collect on their own record. And like someone says in the chat, there are also other rules such as they can't get married.
And I think the another question I saw here, which I don't know if I have a great answer to, unfortunately, is can a parent use their child's back pay to pay off the family's back rent? Not a income related question necessarily, because if a child's getting back pay, presumably that's not related to work history due to child labor laws. But my understanding is that a child's SSI income must be used for the child's benefit. So that's kind of a loose definition. Is housing a benefit? Probably. I don't really have a confident legal answer. I think kind of depends on the specific scenario there. But I know I have seen, I used to do guardianship work, and I have seen that scenario because you want the child to be housed. That some of that, now then you get into how much of the income is for housing, how many people are living there, who else is contributing. It can be sticky, but just keep in mind that most important thing with child's income is that it's used for child's specific benefit. And then I think we can squeak in one last one that I saw. If someone is blind and SGA is 2,700, what about the $2,000 resource limit for SSI? Off the top of my head,
I think it's the same.
Yeah, I think my understanding is, remembering the history of why the blind benefit was higher, is theoretically, I think when they were doing whatever calculation and exceptions, that there may be more expenses associated with that. Thinking, for example, you have a seeing eye dog. You need special accommodations to perform your work. That there offsetting that when they were creating those rules, if I'm remembering correctly. And theoretically, you know, you're using that money every month and spending down, just like anybody who has income from any source, even if you have income that, and this is a good point, if you have earned income that bumps you up above SGA, make sure you spend that down so you're below resource before the next calendar month. So now we're at the end of the scheduled time. So I know folks will need to leave. Thank you so much for attending. We have here the link to our Give Big. If you are so inclined, we would appreciate a donation to our Give Big campaign to help us continue this work. It's a much needed time. I think you understand the difficulties with Social Security. And I see.
There was a question about the CLE credit. Can you explain how we're going to be tracking people's participation?
Yes, the uh if you have signed it, if you registered through um through the link, we see everybody that was registered. And so then we're gonna report everybody that attended through the attendee list today. But if you don't see this pop up in your MCLE, you can also self-report. I do see some people here that looks like there's some doubles, so I don't know how that happened in the guest list. So for some reason, maybe you shared a link or something and somebody else is in here and is not registered under their individual participant name, you can self-report. You can also send us an email. Our email's at the beginning of this. If you didn't actually register, but you did attend, feel free to do it that way. But we are going to be reporting everybody that attended today based off of those that registered. If you did not register, please send me an email and I'll make sure it gets to the folks who are doing the reporting for us. So thank you everybody for attending. Please connect with us on social media if you'd like to learn about when we have upcoming CLEs and programs that we're doing on an ongoing basis. If you want to stay connected and see when we're doing that, please follow us on those platforms. And thank you everyone for attending.